I think we'll get started as well. So, thanks for having me here this morning. We like the theme of GCAP this year being the walls that we've built ourselves, and I think with day one, as well as the keynote which just happened just then, there's been a lot of talk about the walls that people have built and ways to tear them down. So, tearing down walls which help to increase diversity, tearing down walls so that games are more accessible, tearing down walls maybe to get easier funding for games, investment and support as well. Except, not all walls are bad walls. So I wanted to give you a talk today about intellectual property and why building some walls around your work can be an important thing and how that can actually help you instead. So walls are an important theme for this year's conference, and I want you to remember that all walls aren't bad walls. There are some which can be of use for you too as well. My name is Matt Lee. I'm from IP Australia, so I'm actually here on behalf of the Australian government. My initial speaker profile said that I was also from a business called the Big Room, and I actually, in my other life, run an escape room up in Sydney as well. So I'm a game designer, albeit not a video game designer. I run analog, real-life manual games instead. And then I also represent the Australian government, where I'm a senior communication officer, where I work in the startup and small business engagement team to talk to people like yourselves today about intellectual property and how it can help you too. So today, to emphasize, I guess I am here on behalf of the Australian government, and to provide a little anecdote to that, I am from the government, and I do support the video games industry here in Australia as well. So, to give you a little bit of background about IP Australia, so we are the Australian government agency that deals with registered intellectual property. Specifically, that's protection of patents, trademarks, designs, and plant breeders' rights. So I'll be outlining some of the main types of intellectual property that apply to video games at the beginning, and then after that I'll be jumping into some key points for you to take away, especially if you work in the gaming industry, but more generally if you work in the software industry as well, the things that you can take away if there are people out there who are looking to copy your work and what you can do about it as well. So one other thing that I need to also mention is that the information I'm giving here is generally going to be information as opposed to legal advice. Generally speaking, it's always a very good idea that if you do encounter an issue or do have a problem that you wish to tackle, that you go seek the advice of a patent and trademark attorney, if those are the issues that you're facing, or an intellectual property lawyer if you're talking about something like copyright instead. So in that vein, take everything that I say as information only, but hopefully it'll be of use to you and your industry. So, everybody knows a very basic concept of what intellectual property is. It's been bandied about widely in different contexts. I think Australia is one of the most prolific downloaders of Game of Thrones episodes as well anywhere in the world. However, when we talk about intellectual property and also just the term IP in video games, it's sometimes a little bit muddled up. In fact, I actually have a little bit of a gripe when people say, oh, so-and-so publisher or so-and-so developer is releasing a new game IP. Because yes, technically speaking, they are correct. They are releasing a new bit of intellectual property, but it doesn't have to be just every time you have a new storyline, a new narrative, a new type of game, like say God of War as opposed to say Spyro the Dragon or something like that too. Yes, there are new types of intellectual property, but definition, when we're talking about legally speaking, is much broader than that. So when we talk about intellectual property from a legal sense, we define it as the application of the mind to develop something new and original. In the simple terms, that's literally the expression of an idea in some material form. And that can be in many different ways, such as a new invention, a brand, a design, an artistic creation, and that by no means is an exhaustive list. Intellectual property is literally all around you in things that you can't normally see or normally consider. For example, again, if you work in the games industry, if you have a subscriber list, that is intellectual property because it has a very specific and very tangible value. If a competitor was able to obtain your subscriber list and use it for their own marketing and distribution purposes, that would be an advantage to them. So therefore, it's also something which is of value and therefore maybe would be worth protecting. Client lists, things, even the contact list on your phone, is also considered to be intellectual property of some sort. So think very broadly when you hear the term intellectual property bandied about, especially for the next 50 minutes. So I want to give you an overview first, again, of the different types of intellectual property, especially the ones that we do deal with at IP Australia, but I also will be venturing into other types of intellectual property that we don't deal with too. The first one that we consider here is patents. When we talk about patents, we're talking about inventions. Most people, when they hear the word inventions, also think of the backyard inventor tinkering away in the shed, making a physical device with smoke billowing out everywhere. The definition of invention in terms of patents is broader than that too. It allows you to protect not just those physical objects, but also processes and methods. In particular for people in the software industry, that can include algorithms as well, which are processes which do something. So the protection will last for 20 years if you obtain a patent. We also have a secondary system called the Innovation Patent System, which can give you protection for 8 years. When I say protection, it actually gives you the exclusive right to exploit your invention, which means sale, distribute, manufacture, etc., 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 here in Australia. Unfortunately, there's no such thing as a worldwide patent, and more generally speaking, there's no such thing as a worldwide intellectual property right. So whenever you get an intellectual property right anywhere in the world, it's generally only focused on a particular country, and they may have reciprocal rights in other types of countries as well, but it's always going to be per country on that per country basis as well. So when I used to be a patent examiner for many years, so I worked for IP Australia for just over 10 years now, and my first job there was as a patent examiner where I was working in the computing field. So I was doing that for about 7 years, and so in the last 3 years I've been working in communications. Come in, take a seat anyway. Alright, no problems at all. So in my time in computing, I saw quite a few applications which came through my door, and a decent number, I was actually pleasantly surprised in some ways, came from the games industry. This is one application that I did, which was focused on the game LA Noire. So developed by Team Clone-nite, which is based in Sydney as well. It was nice to see there was an Australian application and developing technology too. When this particular application that we were looking at was actually to do with the face scanning technology. So one thing that they tried to do with LA Noire, which is a little bit different at the time, was to actually get mocaps and the facial recognition of the actors, which were prominent actors. There were 20 of them from Mad Men, for example, and actually take them and import them into the game. And they actually put in an application which was for the technology of taking the face capture, and then having that imported. I was examining that. Unfortunately, I did raise an objection, and I don't believe that the application came back as well. Possibly it could have gone through had they worked through the application a little bit more, but that's the type of thing that you can get a patent for when it relates to games too. However, it's a little bit tricky because some people have the idea that you can actually get a patent for game mechanics and things, simple things and ideas which are expressed in video games as well. It's not quite true. There are different approaches to how each country approaches patents and application of it to software as well as to video games. And there is, again, this misconception that if somebody had created Super Mario Brothers and then you said, I've got a character which jumps on a Koopa's head, that you could get a patent for that. What we look for in Australia is the first thing, that we need to demonstrate that there's a technical innovation, solving a technical problem to be able to obtain a patent in Australia. And we contrast that to things which we classify as business innovations as well. So a lot of the time, if you hear about some of the, especially United States patents which have been granted on game mechanics, maybe there's a famous one about the arrow and the direction of telling players where to go in Crazy Taxi that has a patent on it, as well as a dispute centering around that too. That if you have a patent which is revolving around game mechanics, it may have been the case where you could have got a patent on it previously, but nowadays you need to display that technical innovation or that technical problem that it's solving, and then you'll be able to get a patent. Now obviously for people working in the hardware industry, if you're creating a new console of some sort, that's going to be much more relevant. However, don't discount it as well in terms of if you're working as on the development side, because sometimes, again, if you solve a complex technical problem in such a way, such as the example I had before of facial recognition, or maybe it could be player behavior, and sometimes even user interfaces as well, we'll be able to classify and be eligible for patent protection in Australia too. I will come back to patents and how they apply, especially in the United States later, and why it's relevant to you and some of the things that you should be doing about it, even if you don't think that you should be getting a patent yourself, because you also have a role to play, importantly, as game developers here in Australia. Trademarks. Trademarks protect brands. When we talk about trademarks, we're talking about anything which is used to distinguish your goods and services from that of another competitor. Most people, when they think of brands, they think of names and they think of logos. However, it can also apply to the products that you put out through, as well as the games that you publish too. But also don't consider it to be restrictive to just those names and logos. It can be literally anything that you want to have that can distinguish your goods and services. Going out of the games industry, for example, Toyota has a trademark in Australia for the movement of jumping in the air in relation to selling cards. Jetstar also has a similar movement as well in relation to selling planes. Cadbury has the trademark over the colour purple specifically for selling chocolate. And there's also one smell trademark in Australia. Now, the smell trademark relates to golf tees. I don't play golf myself, but supposedly if you have a golf tee, before you put a ball on the golf tee and stick it in the ground, some players, for good luck, will smell their golf tee. Don't ask me why, it's a thing that they do. A company got a little bit clever and said, okay, we can do something with this, and they actually applied the smell of eucalyptus to their golf tees, so that when you smell your golf tee and it smells like eucalyptus, you know exactly what company produced that golf tee. They came to us and said, hey, we got something which is pretty unique that nobody else has, and we said, that's true. Congratulations, you now have Australia's very first smell trademark too. Trademarks last for 10 years in Australia, and they can be renewed indefinitely. So if you continue to use your trademark, you can keep renewing it and renewing it and renewing it. So again, if you happen to be developing games under the same banner in 100 years' time, I say congratulations, your technology is probably out of date, but otherwise you can keep using your trademark for as long as you want to as well. One other little point too is that the R symbols which you've seen around on probably some commercial products can only be used if you have a registered trademark in Australia. It's actually an offence if you slap that onto the back of a title or anything like that if you haven't actually registered a trademark. This isn't the same thing as the little words T, or the little letters TM. So there's no restrictions. If you want to put TM on something, even if it doesn't necessarily have an official registered trademark, you can do that. But R has those restrictions, so just a little bit of trivia for you to keep in mind. Now, trademarks are important in the games industry. This is the game Star Fox 64, which in Australia was unfortunately known as Lilac Laws as well. Also because of a trademark dispute too. It wasn't actually an Australian trademark, I believe from my reading that it was actually a similar name in Germany, which caused a little bit of a problem. But there are relevance of trademarks in the games industry too. So if you have a brand, generally speaking, you ideally want to have that integrity so that you can have the same game, same name, and publish it around the world under the same banner because people are going to be calling it by the same thing. Luckily for them, everybody's focusing on the fact you can do a barrel roll as opposed to necessarily calling it by Star Fox, but it still dilutes the brand when all of a sudden people talk about this product called Lilac Laws, and then you go overseas and people don't know what you're talking about. You go, oh, you mean Star Fox instead. It also extends a little bit beyond the games industry to other types of media too. This is another example of a game all the way back in, I think it was the 80s, perhaps maybe a little earlier than that, called Rampage, where you used to go around as like 3 large monsters and then smash up buildings, climb up them and eat them and everything too. Now, I don't believe that there was a trademark still in existence because that game obviously had a short lifespan in the arcade industry. I remember playing that on my Commodore 64 at one stage too. In more recent times, the thing on the right was a board game which got released, which also was called Rampage, also with monsters which went around and eating little meeples and destroying buildings to extract them too. They recently had to change their name and republish their entire game under the moniker Terror in Meeple City because people were actually thinking that there was a trademark and it was actually made by the people who made Rampage too. So if you don't think about trademarks, even if you have something which you publish as well, and it creates a reputation for itself, even if you don't go and formally apply for registration at IP Australia to get a formal registered trademark, you still have some lingering effects in some instances too, where you can demonstrate that you have a reputation. Because in Australia, there is such a thing called a common law trademark. So if you can demonstrate that you've built up a reputation in the industry, people know your name, like Rampage, and can have that association with those types of products later on, it can have those slightly longer reaching effects. I'm not entirely sure whether there was a direct letter which caused the Rampage board game to change the name, but it still was enough of an issue that they actually republished their entire game as well, which wouldn't be the cheap exercise, especially when you're talking about physical media instead. Okay, so there are another misconception that I also wanted to raise on trademarks before I move on to is what the different types of trademarks and its interaction with domain names and business names and company names. One thing that people make the mistake of is that when you start your game studio or your business, that you go to ASIC, you register your business name, and you say, yep, great, I'm done. I've registered my business name, I've got protection. A trademark is the only thing which allows you to protect your intellectual property in your brand. Registering a business name is simply an administrative task required by the regulations and by the law as just something that you have to do when you're starting a business. it doesn't provide you any protection. Anybody can then infringe on your intellectual property branding rights because unless you have that trademark in place as well. I've taken the example, and I hope there's nobody in the room, but even if you are, that's fantastic. I think Surprise Attacker actually doing a talk in another room right now, so time is very conveniently. But Surprise Attacker I've used as the example because they are a publisher which is based here in Australia, and they have a bunch of different intellectual property rights which all have slightly different purposes. Their company name is Surprise Attacker. They just recently rebranded themselves, but they've kept their registered company name. Their business names that they have registered now is Fellow Traveller Games, which they're known by, as well as another registration under Double Jump Communications. However, their registered trademark actually goes to Fellow Traveller. And that is a registered trademark which has the logo as well as the name. And on top of that, they have another one which I haven't listed here, which is just for the words Fellow Traveller in relation to software and other digital communication goods too. They also have a domain name registration, which is fellowtraveller.games. So you can see that there's different things with different purposes. You can register your company name and your business name, and it can be whatever it is that you need for those purposes. But to actually get the protection in terms of what brands that they want to enforce, they've gone with the Fellow Traveller name itself, and that's what they've registered. One last tip that I have about domain names, that it's often a good idea to try and register domain names early, and I think most people are pretty good at that now too. But one thing that you should also consider is that, especially if you've been in the industry for a little bit of time, is that think about registering more than one domain name. Domain names are relatively cheap in the scheme of things. It's normally like $30, $50 or something like that too. I think Scott Morrison couldn't afford that recently with his particular domain name. But generally speaking, it's affordable. One thing that people have started to pick up on in the games industry is that, or I should say in the legal industry, affecting the games industry, is that if you haven't registered the domain names of your sequels and your game is successful, other people will do that for you. So, if you happen to say, I made the first Assassin's Creed game, and it turns out to be a hit, somebody may have already registered Assassin's Creed 2, Assassin's Creed 3, Assassin's Creed 4, etc., etc., etc. Probably valuable domain names that you would need in the future as well. So it can be the case, again, there's going to be a line in sand because you're not going to go from 0 to infinity for these types of things too, but be aware that you may need to register more than one domain name, as well as other types of suffixes as well, so your .coms, .com.aus, .cc, whatever, as well as necessary, and obviously here they've got .games. So again, it's a little bit of a tip that you may need to consider expanding your domain name registration. In terms of what you can actually get registered for trademarks too, there's one rule which is also very applicable, which is that you can't register for anything which is descriptive. So unfortunately, Euro Truck Simulator 2 is literally what it says on the tin. It's Euro Truck Simulator 2. So if your trademark is descriptive of the goods and services that you provide, you can't get that registered in Australia. If I wanted to register the trademark Apple and I was a greengrocer selling vegetables and fruit, then I wouldn't be able to get that. However, if I want to sell computers, then I can actually register the trademark Apple as well. Untitled Goose Game is something which is coming up as well, which should be published, I think, in sometime in the near future as well. That's probably one of those kind of 50-50 ones as well, because at the moment it kind of is descriptive. It is an Untitled Goose Game as well. So it's going to be a little bit tricky in terms of whether your game is going to be descriptive, but for the most part, I think that most people should be fine and should be able to register their trademark without a problem. Okay, the next one I want to talk about is now an unregistered right. So the two I talked about before, patents and trademarks, require you to actually submit an application to IP Australia before you're granted that right. We have a range of criteria, like the one I sort of showed you before of non-descriptive trademarks. For patents, you have to have something which is new and inventive. So those ones, you actually have the formal registration process. If you don't register with IP Australia, you don't have anything. There are also the intellectual property rights which don't require registration. The first example I have here is about non-disclosure agreements, otherwise known as trade secrets or confidential information. So the way that this works is you have a contract with somebody and you say, I want to tell you a secret, but you probably got to sign this piece of paper to say that you promise to keep it secret. And if you breach that promise, I can take you to court in breach of contract. That's exactly how it works. The most famous example, unfortunately, is not a game example, but it's for Coca-Cola's secret recipe for Coke. They've been around for over 100 years and have done pretty well for themselves in that time too, and they've managed to keep the recipe secret for the entire time. And the reason for that is if you decide to go into the factory and get access to the recipe, you have to sign a pretty lengthy document which will have lots of penalties and things that can go wrong for you if you breach that confidentiality agreement. Unfortunately, they actually, despite the resource of Coca-Cola, they actually came very close to losing that trade secret when two employees decided to grab it in the mid-2000s and run across the road to Pepsi to try and sell it. I'm assuming they're across the road from each other because they're in the same industry. Luckily for them, Pepsi reported the incident and said thanks but no thanks, and then those employees were caught and arguably never heard of again as well as Coca-Cola. But it just goes to show that a company with resources the size of Coca-Cola, which is a multi-billion-dollar industry, came very, very close to losing its trade secret. And that's because trade secrets are fragile. If you ever take them out of the box, it's really hard to put them back in again as well. So it's one of those things that you should have in place. It's a good idea to have, and I can show you the implications of this again later in the games context, but it's going to be something that you have to realize that once it's gone, and then your agreement instead should be focusing on what next. Do I want to get compensation for it, or what else can I do to kind of alleviate the situation a little bit further too. But again, another option, and that's something that doesn't require registration, it's just between private parties. The final thing I want to talk about now is copyright, and I'll expand on this a little bit more because this is probably the most important one. Copyright in Australia is automatic and free. If anybody says that you need to go and pay a fee to get your copyright registered, there's like they're pulling your leg or trying to take your money as a bit of a scam in Australia. You don't have to actually go through any registration process. As soon as you put idea to paper, that's when you actually get copyright. So it's the material expression of an idea. It applies to artistic works, so artwork, paintings. It also applies to literary works and dramatic works, theatrical works, sound recordings, etc., etc. One thing that I'd like to say is that there's been, for the longest time as I've been around, is that there's always that the perennial debate about are video games art. From a legal perspective, that's been settled a long time ago because computer programs are considered to be protected under copyright. So therefore, just like paintings and literary works and the like too, computer games are art. Done. That's what the law says. So tell that to people if they ever raise that. So, computer programs are protected as literary works just like books. So, however, they only protect the expression of the idea and not the idea itself. It says functionality there, but it's like it should be saying more that it doesn't protect the idea itself. So if I decide to write a novel about a boy wizard with a particular shaped scar on his forehead, I can do that as long as I don't lift the words from Harry Potter or take the words from J.K. Rowling. Because again, it's not the concept which is the thing which is protected, but rather the expression of the idea which is protected by copyright. So again, you can understand that it's very limiting, especially when it comes to computer programs or game code as well, because it's going to be the code itself and the expression of the code which is going to be protected by copyright as opposed to the ideas itself. It does extend a little bit further when it comes to games because if you're talking then about artwork and art styles, then it may be an argument that yes, those things have been copied as opposed to having an original realization of the same idea too. But generally speaking, when it comes to computer code, it's going to be the code itself. So again, it can be slightly limited. Cloning. Big issue in the video games industry. It's not a new thing though. So I want to talk now about this particular issue and some of the things that you can do about it. Now, this is obviously the most popular game in the world right now is Fortnite by a fairly big margin as well. I think I saw a picture of there's a tram which is like painted with Fortnite branding, which is going around the city loop, so you can't really avoid that kind of hype tram or whatever you want to call it as it's going around. It's kind of in your face. However, it's like they have made a claim in some ways to being the kind of leader of the battle royale genre, if you want to call it that, which has upset a few people from PlayerUnknown's Battlegrounds. So they, were saying that no, we were the kind of original purveyors of the battle royale format. Not quite true, because as much as Fortnite is the leader currently as well, there were also other predecessors to PlayerUnknown's Battlegrounds. And again, come back to the idea that I said before that you can protect with copyright the expression of the idea, but not the idea itself. So the concept of a battle royale game isn't something which is protected by copyright. So as much as PlayerUnknown's Battlegrounds wants to say that yes, battle royale is something that we own, they do not own it. They may say that we were significant contributors to it, and they themselves were not the first H1Z1 or H1Z1 if you're American was another game which had a battle royale mode. Prior to that, there was a mod in Minecraft which had a battle royale mode, which was based off the movie The Hunger Games. And prior to that, obviously, there was the movie and the novel itself, Battle Royale. So the concept of a battle royale type mode has been around for a long time, but it's the actual execution of it itself which is the important thing. So Fortnite has the unique characteristics of being able to build structures and do other types of things too, which perhaps wasn't present in the other games. And that itself may be something which is unique, but again, remember, it's the expression of the idea, not the idea itself which is protected. So let's move on to what you can do if you actually run into problems yourself in terms of intellectual property. And these are the key points which I'll kind of go through step by step to say I want you to take away from this particular session. Number one, registration is important. And I want to expand that a little bit more broadly to say, think about what kind of protection mechanisms that you have in place. Number two, have written agreements in place. It's also very important. Number three, know what you own and what you are going to be responsible for. Number four, tap in your community. And I mean that more broadly in terms of saying the gaming community as a whole, as well as just more your local community here in Australia in terms of the game development scene. And finally, keep records and consider publication too. All right, now that you've got those in your head, let's step through them. Number one, registration is important. I mentioned before that there are some types of registration that people can adopt. Patents if you work in technology or have something else in type of technology, but also trademarks if you want to protect your brand. I recently came across a story about Siege Sloth Games, which is, I think, a Canberra-based game development studio as well. They recently had an instance where their logo, despite being up online for everybody to see, was ripped off. And somebody created a YouTube channel which wasn't quite called Siege Sloth Games, but also had the idea of sloth, but had taken the logo basically and copied it directly as well. The first reaction that people have just when their work is copied is to say, I'm going to go to court, I'm going to sue them, I'm going to send cease and desist letters, I'm going to take them down, I'm going to sue the pants off them as well. First of all, consider your steps and consider your options. Number one, do you have grounds to actually sue them in the first place? The best way that you have a reason or the basis to sue people for a start is if you have some form of registration. You need to have some kind of, to take action, generally speaking, to give yourself the best chance, you need to have some form of registration. In this case, it would be a trademark registration here in Australia, because, or it necessarily, it may also be the case where you have a trademark registration in other major markets, such as the United States as well. Second thing is that even once you have your basis for suing somebody, is that necessarily the best option? Think about and do your investigation to find out a little bit more about the story. So take a moment to calm down, just breathe, and then see what you can find out first before you go absolutely nuclear, because it may not necessarily be warranted. Now, I mentioned that registration is important because they did some investigation themselves after they had that little moment of panic and got a little bit uppity, and found that the actual person who was infringing on their copyright, or the trademark I should say, was a kid who just had their own YouTube channel, who saw that he wanted to have something which is called a sloth, did a Google image search for sloth, and then came up with the logo for Siege Sloth Games. Think about the publicity if Siege Sloth Games had gone nuclear and gone and sued a teenager living in the United States who just wanted to have his own sloth YouTube channel as well. Not necessarily the best of looks. But the more other option that they had too was to remove the imagery from YouTube itself. However, this is the response that they received from YouTube. Now, most of the platforms around the world, such as YouTube, as well as the things for apps such as Google Play, iTunes Store, etc., will have takedown provisions, but they will generally only enforce them if you have a registered intellectual property right. In this particular instance, SiegeSloth didn't have a registered trademark, and so they got this response here to say that they couldn't take it down because they couldn't verify their trademark rights. This was a little bit of a lucky shot for them because, again, it was only a kid which wasn't going to go and make a cloned game. But can you imagine the situation where they were actually properly infringed, somebody had made one of their games or were using their particular game title, and they didn't have something in place? So, by having that level of trademark registration, that gives you the power to then take options. You don't necessarily have to enforce it. It's often a good idea to because you don't want to dilute your brand, but those other mechanisms which are available to you will only work if you get that level of registration. The other important point to note is I mentioned before that there is no such thing as copyright registration here in Australia, but that's not true for overseas. In the United States, which again is the biggest market for most game distributors as well as publishers, you can register your copyright. You don't have to. Copyright is recognized under international treaties as applying to all types of works which you can get copyright for, and you can sue somebody for copyright infringement if you haven't got anything registered. But the level of enforcement options that you get are severely limited if you don't. So it only costs you like less than $100, I believe, don't quote me on that, but less than $100 to get your copyright registered and as a deposit in the United States. If you do that, you get access to more significant damages in major cases where there is significant copyright infringement, but more importantly, it also allows you to then to go to people like YouTube, Google, Apple, etc., Amazon, and say that my copyright's been infringed, can you please remove it? And they will more likely pay attention to you because it's there on the register for them to see too. So that's why registration can be important. Okay. Number 2, have written agreements in place. I mentioned before that non-disclosure agreements can be something which is important for you to have. Think about it in 2 contexts. Number 1 is that if, yes, you have a situation where you talk to other people who might be potential partners, potential employees, potential contractors. Generally speaking, in the game development scene, unless you happen to be a solo developer, you're going to be relying on a lot of other people as well to help you create your game, whether it be your art assets, doing your writing, maybe doing some coding, doing some marketing, communications, publishing your game. Have those written agreements in place, even if they're your friends, and I know a lot of people will tap into kind of personal connections too, because it helps you when things get messy, and things can potentially get very messy. As part of that, consider what you're going to have in there, which is going to be sorting out your ownership, as well as sorting out what you can and can't disclose as part of that arrangement as well. This example here is from Riot. So, maker of League of Legends, and I'm a League of Legends player, so I do have another example in there. Sorry for people who play Dota. But I do have an example here where Riot, have this multi-billion-dollar game. It's a very, very, very successful game in the mobile industry too. They are primarily PC-based, but they don't have an equivalent game on mobile. And somebody saw that there was a gap in this market and created their own type of League of Legends style game called Mobile Legends as well, which is based from China. Unfortunately, the person or the CEO of Mobile Legends used to work for Riot. He, as part of his employment agreement, or his contract, signed an agreement which included a non-disclosure and non-compete clause, meaning that he had to keep something secret, as well as the fact that he was able to create a rival business under the terms of that agreement. He did. Mobile Legends picked up with a lot of steam and is also worth quite a lot of money as well. Riot tried unsuccessfully for many years to shut them down, so using those mechanisms I said before of taking them down on the App Store, and about 2 days later they pop back up again with new art assets, new titles, but essentially the same game. There's also an issue here about copyright infringement because most of the art style and game mechanics are basically direct copies of League of Legends. I don't have an example here, but there's like 2 characters. One's called Annie in League of Legends, and her ultimate ability is to summon a giant teddy bear. And there's another one which is in Mobile Legends, which does exactly the same thing, except I think it's a slightly different stuffed animal instead. It literally is exactly the same though, right, in terms of concept. So there is a copyright infringement potential issue here too. Tencent, which is the large Chinese company which owns Riot, especially in China, sued Mobile Legends under the non-disclosure and the non-compete clause. They also have an action for copyright infringement. Can somebody tell me, they did win their case very recently against the CEO of Mobile Legends. Can somebody just give me a random guess as to how much they would have got in damages? Just give me 30 million? $4 million personally against the personal director. Not the company, this is against the personal director for breaching non-disclosure and non-compete clauses. And I told you again, we still have the copyright infringement claim to come as well. It can cost you a lot of money if you're on the bad end of this. But again, I'm talking to you as developers. Don't be right in this case as well and have your game taken away from you because you don't have those agreements in place. It can happen, it will happen, and it can sometimes be worth a lot of money too. So something to consider, you need to have those agreements in place. And again, early as possible. Know what you own and what you're responsible for. Here's my other League of Legends example, so I'm just really bombarding you right now. So, this is for the streamers, people who kind of work in the publishing side of things. So, when we talk about games, and you go to, say, well, I don't know how many people do this nowadays, but you go to a physical video game store, say EB Games, and you decide to buy yourself a disc, or something like that too. What are you actually buying? You're not actually buying the rights to the game. When people say that I own X game, they don't actually own X game. You are given a license, generally under terms of service, to be able to play and use the intellectual property of the company that produced the game. And generally speaking, the development company will assign those rights, or at the very least license those rights, to publishers and distributors too. But as a player, you don't generally own the game. It's all controlled by the game itself, and generally all the intellectual property is retained that way too. Streaming is a new kind of phenomenon in the last few years too, and that presents an interesting challenge because people are performing their own creating their own intellectual property work, and there are people who put in a lot of effort into making the streams entertaining for the public too. But essentially, if they're streaming themselves playing a game, who owns that particular stream then? The answer to that is complicated. So the gentleman on the right here is a guy called Faker, who at one stage was regarded as the best League of Legends player in the world, based in Korea too. Won multiple world championships with his team, and again is widely regarded and held in the industry. He has his own stream, and originally I think again a few years ago, he was signed a contract exclusively with Azubu to have a stream under their channel as well. So he would play games, provide commentary on the games that he was playing, people would submit questions, etc., and live broadcast that under that particular agreement. Somebody else decided to say, this is a good thing as well, but rather than getting people to sign up to the Azubu platform, this other gentleman, I assume they could be, I'm not sure what gender, but this other person, I should say, was then streaming the same games on another platform in contravention of that exclusive platform. Now, remember that Faker actually signed this agreement with a streaming platform, so Azubu, which would be the equivalent of signing up with Twitch or something else like that too. This wasn't an agreement with Riot, who are the people who actually make the game as it's being streamed. So the question then becomes, can anybody shut down this other streamer and have any kind of action against them? Because Azubu's rights, and certainly Faker's brand as well, is being diminished because there is a separate product which is copying the exact same game and broadcasting the exact same thing live at the same time. The other complicating factor here too was that if it was a direct copy of the Azubu stream, and then you copied that and then rebroadcast that on your channels, it would be a pretty clear-cut case of copyright infringement. Except he didn't do that. What he did is he tapped into the game that Faker was playing and using Riot's spectate mode to then stream the game simultaneously. So when he saw that Faker was online, playing a game, he would just say, I'll watch it, just like anybody else in the world can watch it using the same platform and see what I can do. What eventually happened is that Riot weren't happy with the situation, but again, they were the ones who were going to ultimately decide it. It wasn't Faker, it wasn't Azubu, but it was going to be Riot, because again, they own the game, they own game assets, and including in the copyright is the right to publish, broadcast, and otherwise distribute your game too, which includes streaming. So, once they were notified of the situation, they actually shut down the other streamer because it was in contravention of their terms of service. But mainly because that they wanted to side with Faker, who's one of their best kind of personalities and assets, and says that it's not a good thing for you to be doing this too. We are the ones in control, and therefore kind of shut that down, ask them to shut down that stream. So you can see that as a responsibility as a game developer or as a publisher as well, that you have a lot of power to control what happens with your game too. The other thing of note though too is that you do also, it can be a double-edged sword, because as much as you want to empower players nowadays too, you can also get yourself into a bit of hot water in terms of what you allow your players to do. This is the game City of Heroes, and as you can tell, these are slightly familiar characters, albeit kind of very badly drawn ones, because they're using the in-game engine and the in-game assets. So Marvel took issue with City of Heroes, and this case was eventually settled. but Marvel took issue with the Game City Heroes because players themselves, as opposed to the company, were creating replicas of Marvel superheroes and their costumes using the in-game tools available to them as well. The question is, Marvel didn't sue the players who were doing this, but they sued the game company behind it instead, NCSoft. So, is NCSoft liable for the actions of its users? As a general proposition, what we have in Australia, actually what's known in the industry, in the legal circles for this, is a concept called safe harbor. So in instances you can be, as a provider of a service or an online platform, you can be held liable for other users using your platform for copyright infringement in certain circumstances. We'll look at factors such as, did you authorize the infringement? Do you have tools or do you have the power to shut them down? Do you have any policies in place to shut them down, etc., etc.? So they're the types of factors that we use. In the US, there's exceptions for safe harbor, saying that if you have a commercial entity, sometimes you have exceptions to that more broadly to say that you as a platform provider aren't liable. In Australia, however, we don't. We have the exception only in place for things like ISPs, so there's the INET case where people are downloading copies of the Dallas Spiders Club. We also have other instances where you can get an exception if you're an educational institution or some other kind of charity instead as well. But if you're a commercial operator that hosts an online platform, which includes games that allows user-created content, that you may be in certain circumstances liable for the things that people upload. So, I don't want to tell you to move all your operations offshore, but I'll let you make your own decision in terms of where you might be like hosting your servers, etc., if you're going to allow people to do that. In this particular instance, they weren't held to be liable to be infringing on Marvel's copyright in the first instances for some claims. Some claims went unresolved and they settled in the meantime as well, so both parties have kind of claimed victory. So not quite clear, but again, it can be a bit of a sticky situation if you allow people to do that. 4. Tap in your community. Your gaming community can be a really good resource for you as well, and they can actually help you in some of your legal disputes. This is a copyright infringement case from the United States for an app. So there's a game called Triple Town, which is developed by Spryfox, who managed to sue Yeti Town for cloning their particular app. One of the key things that the judge found in this particular case was that as evidence, they actually used a lot of blogs that people had written about Yeti Town and noted that they all said, wow, this game is really, really similar to Triple Town. They're a really difficult kind of, it can be a difficult situation when somebody clones your game in terms of what kind of actions you can take. But one thing which is proven to be effective in this particular instance is if you get the gaming community behind you, so the users that you have acquired as part of your game, as well as the developers around you, they start talking about the similarities between the clone game and your game and be able to get that level of public support, that constitutes evidence. And that evidence can be used in some instances in these disputes to say that yes, there is going to be some level of copyright infringement here because they have literally duped those users who are the people who are your audience and your paying customers into thinking that they are the same game as well. That again was settled before it was finally resolved, but that comment from the judge in preliminary hearings did explicitly say that yes, there is a potential for copyright infringement here. Here's the blogs to prove it too. Finally, consider what you want to do in terms of keeping records and publishing your games. A lot of publishers or people who make games will come up with different game concepts, things that you kind of muck around with and never see the light of day as well. So I mentioned before at the beginning that I used to be a patent examiner, and I saw a lot of applications which came through here. This isn't one that I did directly, but it's very similar to one that actually came across my desk called Xbox Achievements. So this is a patent which is done by Microsoft, and they do love to get into the patenting industry to file for different innovations that they create. Achievements was something that they decided to claim. And I spent a long time examining a case where they basically said that we created an achievement system for players to receive a feeling of recognition and worth as they decided to play the game. And achievements aren't a new thing. I actually cited a case against them from Atari, I think back in the 1970s, where Atari used to, for some games, I think it was Summer Olympics or something along those lines, used to mail out badges. I'm serious. We kind of sew badges to people as achievements to give to people as well. But the technical details of the way that Microsoft did their achievement system was the hard thing for me to overcome as well. So the hard part for us as patent examiners is that we can only object to something and reject applications if we have the evidence in front of us to say, Yes, somebody's done this before. I've seen this around, except it's hard because a lot of things go by the wayside. I can only do it in terms of published information, published documentation, which is where you come in. As good practice, it's a good idea for you to kind of go through the development cycle, keep documentation of the ideas that you have and you put them down on paper, the artwork prototypes that you might develop, the initial bits of code, etc., so that we can see as a point-in-time reference when things are being made as well. And the more important aspect of that is you decide what you want to publish. Now, if you're working on something, maybe it's not a good idea to kind of publish everything as you're going along, especially if it's going to be something that you want to release commercially. But for all of those projects that you previously did, what are they doing, sitting in your back pocket for as well? If you feel that it's something that you want to contribute to the community to stop other people from claiming it as their inventions later, maybe consider publishing your work, as well as the records that you kept during that process too, because if we can find it as the Intellectual Property Office as well, then we are able to use that and cite that against those applications from other people later on, if that's relevant too. So, those are the points I want to, again, just leave you with too. Again, register registration of your intellectual property. Have those written agreements in place. Know what you're responsible for and what you own as well. Tap into the community and your community, and then consider the records that you keep and consider publishing them as well. This is a little bit of a highlight of information which we're producing at IP Australia. So in the very recently, we just published a package of work which is for digital business, in which case the games industry sits squarely in as well. It goes into a slightly more detail. For example, with written agreements, gives you some pointers into what terms of what you should include in your written agreements when it comes to retaining ownership, especially with people such as contractors that you might use as well. I endeavour you to check it out, and more to the point is that, again, I go back to what I said before, that I'd like to find ways to support the Australian video game industry. If you have an issue with intellectual property, wish to share your story for other people to hear, I'm actually in the process of collecting stories to publish as case studies as part of this particular package of work. I'm happy for you to talk to me after the session, or get in contact with me. Otherwise, I do have some business cards in there too as well. But otherwise, again, think about intellectual property. It is a very important thing that a lot of people don't think that they have time for as well, but it's something that you should all consider. And again, thanks for your time. Yes, questions?
So I applied for a trademark a couple of years ago for my business name, and I was looking into doing the Madrid protocol,
yep.
And I couldn't see easily at the time that I could do that on the IP Australia website, but I've recently heard that you can.
Yep.
Can you confirm?
Yes, you can apply for the Madrid protocol. For those who aren't aware of what that is that you can't apply for a trademark which covers the whole world. You know, there's no single trademark which covers the whole world. What there is a system called the Madrid protocol, which allows you to file a single application in Australia after you filed your Australian trademark application, and use as the basis to basically broadcast that to all the countries that you wish to select off a checklist as well. You have to pay fees for each one. They'll examine them under their own national laws, but it's an easier process than filing individual applications in every single country that you wish to go to instead. And yes, that option is definitely available, has been for quite a number of years, and most basically countries around the world now are signatories to the Madrid protocol, so you can absolutely do that.
So you're just saying to e-services and...
Absolutely, yes, and we do have information on the Madrid protocol on our website, so if you need help or assistance in doing that.
Okay.
No problems. Yep.
You may have already answered this, but I came in late.
No problems.
The thing about trademarks, you said that they can be renewed indefinitely.
Yes.
How would the steps go if a trademark were to expire, but then the person who did hold the trademark before it expired wanted to renew it then? Would they apply for it again? Or?
No, there's just a renewal fee that you need to pay. If your trademark is still active, and then just before the 10-year mark, we'll be saying, hey, by the way, you've got a trademark which registered. Do you want to renew it? Yes or no? And then we'll send you that letter, and then you're able to pay that fee, and then that's all you need to do. There's no re-application process.
Right.
So we don't re-examine it.
I'm also wondering, after it's already expired.
If it's expired, then you'll need to reapply for it as well, because there could be an instance where somebody is then snuck in that expiration date to apply for the same trademark, in which case then they may have got in first as well. If that's not the case, then you should be fine. You should be able to get it revived, I guess, in a way, through a new application. Yeah. Yes?
In the case where people are creating Marvel characters for
Yep.
games, how do they differentiate between a theme, like a game that allows you to create Marvel characters, and like Photoshop or like art?
That's right, yeah. So, yeah, they in a way that they will look at the ability of and the kind of tools that you provide as a game creator to your users to enable the infringement to occur as well, which is a difficult thing because, again, with sandbox games, if you think about Minecraft, for example, you can do a lot in there. You can do heaps and heaps and heaps of things as well.
So would Minecraft's defense be where or not?
Well, probably not, because again, the primary purpose of those games is to be a game, and that's one thing that they also considered with City Heroes, and would also occur with things like Photoshop, is that it's for photo editing purposes or something like that too. If you literally call your thing a Marvel character editor, you could be in a bit of trouble there as well, because it's clear just what the purpose is going to be. But for City Heroes, because there was another game built into it, their own narrative, their own storyline, their own quest system, etc., etc., and maybe there were allusions to Marvel references, but it wasn't about that as well. You could clearly say the primary purpose of the game is a game, and just because there's a little bit where people can just make their own Marvel characters, then so be it. In fact, one thing that they've done recently is that they do pick up on any kind of likeness characters, and if you decide to call yourself the Incredible Hulk, your name will automatically get changed within half an hour to generic something as well, which is playing it safe. But fair enough.
I might have to empty the room.
No problem. All right. I'll be outside as well if you've got any further questions, but again, thank you very much.